Good afternoon, ladies and gentlemen, and thank you for connecting. My name is Teodora Toma, and I am the Executive Director of the World Jurist Association. On behalf of our President, Javier Cremades, and the entire organization, I would like to welcome everyone to today's session entitled Rule of Law, Energy Transition, and Climate. Which is a very important and critical topic in today's society, and it is organized within the World Jurist Association Energy Transition and Climate Forum. Let me thank the World Law Foundation for organizing this event, and especially Jackie Rodriguez for coordinating the session. And let me also remind you that all of our opening sessions, such as the one held today, will be celebrated again, but live, during our next World Law Congress to be held in New York in July 2023. Sorry. Without any further ado, let me briefly introduce Mr. Kari Kuusiniemi. Also extend him a big thank you for his implication and for the great level of speakers participating in today's session. Speakers that were recommended to us by Kari. Kari is the president of the Supreme Administrative Court of Finland. And from his long and impressive professional career, which I cannot mention all, I would like to highlight, because of the relation that it holds to today's topic, his commitment and experience in the field of environmental law, both at the academic level at different universities, not only in Finland, but also in other countries, as well as at the institutional level. Mr. Kari Kuusiniemi will briefly introduce the topic of the panel as well as the speakers. And at the end of the session, he will draw the conclusions and close today's session. So again, thank you very much to all of the attendees from all over the world for following us live or recorded on our YouTube channel. I look forward to seeing you all in New York next July. And of course, thank you very much, Kari, for all your collaboration and great willingness to participate with us today. So Kari, you have the floor.
Thank you so much, Teodora. It's always a pleasure to cooperate with World Jurist Association and you personally. So also on my behalf, I would like to warmly welcome each and everyone to follow this very topical session today concerning the rule of law, energy transition, and climate. And my task here is just to set the scene and then let the real experts to give their profound comments and analysis on this very interesting topic. It may be mentioned that the topic is really acute at the moment because in Egypt, Sharm el-Sheikh, the COP27 is just going on, and it also affects some of the organizations of this session, which I will refer to later. But starting from climate change, it's nothing happening in distant future. It's here and now, at present. Examples are commonplace. Extreme weather conditions, floods, for instance, in Pakistan, where 1/3 of the area of the country was recently covered by flooding waters. Melting icebergs and glaciers, droughts in the Horn of Africa leading to famine, devastating forest fires in California and Australia. Human-induced global warming has changed the living conditions and natural environments all over the earth. The scientific community, at least almost unanimously, confirms that these radical changes are to a large extent due to greenhouse gas emissions from different human activities, such as industrial activities, traffic, and energy production. What have we done thus far? The United Nations Framework Convention on Climate Change was done in Rio de Janeiro in 1992. Paris Agreement, which is the most important convention under the umbrella of the Rio Convention was signed in 2015 and adopted by 196 countries. It is a legally binding multinational treaty, the aim of which is to limit global warming well below 2, preferably 1.5 degrees since pre-industrial times. But how about the implementation and enforcement of this treaty? The aims of the present societies is to achieve carbon neutrality or negativity, and there are different EU programs and legislative schemes, just like Fit for 55, etc., etc. Many political decisions have been made, and legally enforceable obligations towards zero emissions and energy transition to renewable energy sources, just like wind, solar, wave, and nuclear, are taking place. But now, as we are facing the cruel war by Russia on Ukraine because of the sanctions imposed by the West, by EU, Russia is now using energy also as a weapon. Already at this stage, I'm very happy to mention that the next speaker, Professor Iliadou, will elaborate the role of energy transition very soon. But as the topic of this session is the rule of law, we'll first set the scene by emphasizing one of the most crucial elements of the notion of the rule of law, which is, of course, separation of powers in the spirit of Montesquieuan tripartition. It's legislature, executive, and judiciary. Courts, of course, are under the obligation to obey the law. That is the element of legality. But societal decisions, which are made by political, democratically elected decision makers, are not, in the first place, supposed to be done by independent courts or by judges who are appointed on non-political merits. But on the other hand, an essential part of the rule of law is guaranteeing fundamental rights and human rights. I refer to the Treaty of the European Union, Article 2, and Venice Commission's famous rule of law checklist. But the key issue is that if political decision makers fail to proceed as rapidly as expected, can or shall the courts fix what has been neglected? And how? Can they force the executive, the governments, to act, and on what grounds? Can inadequate national legislation be superseded? These are relevant questions, and I sincerely hope that we will get some answers from the prominent speakers coming after me. And in a very remarkable role in the thinking of the court's role in attacking or tackling climate change are international human rights obligations. For example, the European Convention of Human Rights and Fundamental Freedoms and its provisions concerning protection of life and private and family life. And also, we have to keep in mind that national constitutions often include environmental clauses aiming to protect also future generations. We have noticed that in very many different countries, strategic climate litigations have recently taken place. The idea behind these strategic litigations is to push the courts to make the executive act according to international obligations. Very well-known Dutch cases are Urgenda and also Shell, which both are based on decisions by general courts of law, Urgenda by the Supreme Court. And the basis of the reasoning has to a considerable extent been human rights obligations. Also, a case from Germany by the Federal Constitutional Court concerning the German Climate Act has been often referred to. And from Nordic countries, we have noticed the case concerning oil drilling concessions in the Norwegian Arctic area. And we have also several, let's say, normal, typical cases from national jurisdictions where climate has been defended by the national courts, or at least people have tried to make the courts to defend the climate on these bases. And now let's move to the program. We have now the next speaker, Professor Ekaterini Iliadou. She is Associate Professor at the Athens Law School, Department of Public Law. She is attorney at law, consultant on legal and regulatory affairs. And her topic is climate change and EU legislation on energy transition. Professor Iliadou, please, the floor is yours.
Thank you, Mr. President. It is a great honor for me to participate to the World Jurist Association Energy Transition and Climate Change webinar, together with all the other prominent speakers. Therefore, I would like to thank the organizers for giving me this exceptional opportunity. As you mentioned before, my contribution today is entitled Climate Change in EU Legislation on Energy Transition. I would like to begin by trying to describe the importance of climate change for the energy policy. Addressing energy and environmental issues is of central importance for modern policy making and by extension for the legal order. Firstly, it is a common topic that energy is vital for everyday human life and well-being. Thus, energy has a public good importance in the sense of avoiding any energy supply disruption or shortage, and public intervention for the security of supply is commonly justifiable. Furthermore, affordable energy is essential for households' income and competitiveness and growth of all economic sectors. Public interventions to address energy price crisis or abnormal price hikes are commonly justifiable. At the same time, energy is an important source of environmental damage both for local and regional pollution and for greenhouse gas emissions from fossil fuels that cause climate change at the global scale, which constitutes an unprecedented threat to humanity. Environment protection, and notably climate change mitigation, is also a reason to justify public intervention. Traditionally, public intervention in the energy sector aims at serving the three energy pillars, that is, security of supply, economic efficiency, and environmental protection. Often, between such policy objectives, conflicts may be observed, since it is not always self-evident or easy to achieve simultaneously and equally all three dimensions of public interest. Therefore, Balancing between these pillars is understood as inevitable, as a necessity for defining priorities as considered appropriate at each time. During the last decades, energy policy is directly linked to the necessity to effectively deal with the ever-worsening effects of the climate crisis. For such purpose, climate crisis creates a new framework. Considering that climate constitutes an ontological precondition for the normal continuation of human life on the planet, the necessity to combat and mitigate the problems associated to climate crisis creates fixed policy priorities. Environmental and climate protection objectives gain importance and become top priority. On the other hand, economic efficiency and security of supply need to be addressed through the application of measures aiming primarily to serve climate-related objectives. The aim of the following presentation is to examine if current EU energy policy and legislation is in line with that observation. I will try now to describe the EU energy policy and the policy on climate protection. During the last decade of the 20th century, EU energy policy focused principally on the goal of achieving market liberalization, aiming at enhancing economic efficiency by abolishing the monopolistic structures of the past in line with the general framework of the internal market objective. All three consecutive packages of EU energy legislation that were adopted during the period from 1996 to 2009 focused on the necessity to set the general context for efficient organization and operation of the liberalized energy market to achieve market integration. In parallel, based on the EU competencies on environmental protection, specific measures such as renewable energy sources specific or energy savings related legislation were adopted. Such legislation served mainly as a legal basis for the justification of deviations from free competition rules by permitting state aid to facilitate investment in environmentally friendly technologies and activities. Within the same framework, the most prominent tool of the European legal order for influencing and guiding private business activity in the energy sector towards environmental and climate objectives has over the time been the EU ETS system, a system of tradable emissions allowances aiming to reduce greenhouse gas emissions through a market mechanism. From 2000 onwards, the structural link between energy and environmental EU policy may be observed, leading to a new architecture of the related legislation. This may be explained also because of the introduction of the new Article 194 in the Treaty on the Functioning of the European Union with the Lisbon Treaty. Article 194 is an energy-specific provision at the level of primary EU legislation, stating the necessity to coordinate energy and environmental policy and defining the targets of such policy, which are related to the establishment of the internal market, to EU security of supply, the promotion of energy efficiency, savings and renewables, and to the interconnection of the energy networks. The new treaty provisions created new dynamics by providing the necessary legal basis for the structural interconnection between energy and environmental policy of the European Union. This became evident with the Commission communication of 2015 on the Energy Union, aiming at achieving transition to a low carbon, secure and competitive economy. And later, with the so-called Clean Energy Package. The latter was proclaimed in 2016 and adopted during the period of 2018-2019. This fourth legislative package for the energy sector includes a set of interrelated rules that reveal the basic policy objective to coordinate economic efficiency goals with climate policy. The leading legal instrument within the Clean Energy Package is the governance regulation. This regulation, first of all, established a stable governance system comprising planning, monitoring, and reporting obligations through integrated national energy and climate plans, aiming at the efficient coordination of national and EU policies as regards the achievement of climate targets in line with the Paris Agreement. And secondly, the same regulation granted competencies to the Commission to assess progress towards the achievement of the aforementioned climate objectives and targets, and to make recommendations to the member states to increase their ambition in case their contributions are deemed insufficient. Following the pandemic and the war conflict in Ukraine, after the Russian invasion, new challenges often referred to as energy crisis aroused. Such challenges are related mainly to the management of the unprecedented high energy prices that have occurred in Europe, thus putting energy security of supply at risk. According to the Commission, the necessity to effectively address similar problems requires a coordinated policy shift towards a zero-emission economy. This is the aim of the Green Energy Transition Policy, for which the EU aspires to lead the way, mainly through the European Green Deal, the European Climate Law, and more recently, the communication on REPowerEU. In 2021, with its communication entitled Delivering the European Green Deal, the Commission unveiled its plan to meet 55% emissions reduction by 2030, the first step of the carbon neutrality until 2050, aiming to make Europe the first climate-neutral continent. The EU Green Deal set up the blueprint for the green energy transition and is expected to create new opportunities for innovation and investment, as well as to create jobs and growth, to address energy poverty, to reduce external dependency, and to improve the EU citizens' health and well-being. In July 2021, a new piece of legislation, namely the EU Climate Law, entered into force. With the provisions of this regulation, the objective for the Union to reach climate neutrality by 2050 becomes legally binding, and an ambitious, legally binding 2030 climate target of at least 55% reduction of net emissions of greenhouse gases as compared to 1990 is endorsed. Additionally, the Fit for 55 package has claimed that is a set of rules to revise and update the existing EU legislation and to put in place new initiatives with the aim of ensuring that EU policies are in line with the predefined climate goals. The procedure for the adoption of such proposal is still pending and ongoing. As the energy crisis becomes deeper, the above policy is furthermore confirmed by the subsequently published REPowerEU plan, which set up the framework to rapidly reduce dependence on Russian fossil fuels and accelerate green transition. According to the Commission, there is a double urgency to transform Europe's energy system, ending the EU dependence on Russian fossil fuels, which are used as an economic and political weapon and cost the European taxpayers nearly 100 billion euro per year, and tackling climate crisis. For such purposes and for phasing out EU dependency on Russian fossil fuels faster, the REPowerEU plan includes measures on energy savings, diversification of energy supplies, and accelerated rollout of renewable energy to replace fossil fuels in homes, industry, and power generation. I will try now to assess the energy policy, the EU energy policy, with regards to climate. The assessment of the current EU policies in the field of energy and climate shows that even under conditions of increased uncertainty, such as those of the current severe energy crisis, the basic option for the decarbonization of the economy and the pursuit of predefined climate with the EU's international commitments are not negatively affected, since acceleration as regards the achievement of such goals is repeatedly confirmed. However, the policy measures promoted to date have been largely constrained to setting climate protection targets and enhancing cooperation through governance mechanisms. On the other hand, the adoption of clear and concrete legal rules for ensuring that such targets are effectively achieved, thus confirming the overriding public interest importance of climate protection in the context of balancing between competing policy objectives, is still missing. In other words, the policy proposals and measures formulated at the EU level up to now do not include new rules of structural importance for the organization and operation of the liberalized energy market. What such rules could be is still to be explored. For instance, such rules could explicitly provide for the overriding importance of climate protection objectives in case of conflict with other policy objectives, such as, for example, spatial planning or even environmental protection goals. The Commission's proposal to systematically promote renewable energy investments, even at the expense of spatial planning restrictions, for example, follows that logic. The same is valid also with regards to the proposals for an emergency regulation on the acceleration of renewable investment. However, up to date, such proposals have not been transformed into applicable legislation. Similarly, the existing legal framework does not yet tolerate systematic and easily justifiable deviations from free competition rules, such as the treaty provisions prohibiting state aid or the rules prohibiting restrictions on interstate trade to facilitate the pursuit of climate objectives. Moreover, the existing legal framework has not reached a degree of maturity that would easily justify severe restrictions on economic freedom, for example, by imposing concrete obligation to invest in green technologies, or by imposing an obligation to comply with environmental, social, and governance standards through the establishment of specific legal consequences in case of violations of such standards. To sum up, climate change constitutes a challenge which significantly differs from traditional environmental protection problems. It formulates a challenge for the normal continuation of human life on the planet, thus having the capacity to negatively affect the living conditions of future generations in such a way that cannot be overturned. To effectively combat climate crisis, it is currently necessary to declare at the level of the constitutional order the specificity and importance of the need to adapt the entire legal order to climate protection goals and to adopt clear and legally binding rules that have the potential to guarantee the predefined objectives. Thank you very much for your attention.
Thank you so much, Katerina. It was a very multidimensional presentation, not just touching the very significant link between energy production as a necessity for society and climate change, but also linking it to energy markets, economic freedom, competition, and state aid legislation. Thank you. As mentioned, the next speaker online will be Dr. President of the Belgian Constitutional Court, Luc Lavrysen. He's been justice at the court already since 2001. He's Professor Emeritus of Ghent University, where he was director of the Center of Environmental and Energy Law. Luc has had and has several very important international assignments, including, for example, the EU Forum of Judges for the Environment. And President Lavrysen's topic is constitutional issues, separation of powers, and the rule of law. Please, Luc, the floor is yours.
So thank you very much, Kari, for this introduction. So climate change policies and laws have from time to time, I think, a huge impact on polluters or consumers. And therefore, it's not surprising that those affected by those policies are also from time to time complaining that their constitutional rights are violated, be it the freedom of enterprise, the protection of property, equality before the law and non-discrimination, or basic legal principles as legal certainty, legality and proportionality of criminal offenses, penalties, and so on. So, and I would like to illustrate it by the case law of my court. So cases in which climate change was present. And the first case goes back to 2006. And in that case, the court found no discrimination of steel companies compared with the non-ferrous and the chemical industries. And the court ruled that in the first commitment period, it was justified to start applying the ETS, so the European Emission Trading Scheme. And so the case was about regional transposing legislation of the European directive, that it was justified to start to apply that system to the largest emitters first. Climate change policies justify set the court limitations on freedom of enterprise and property rights, and the court found neither a violation of the freedom of establishment. And importantly, 2 years later, the Court of Justice of the European Union, dealing with the directive itself, came to the same conclusion. second case of 2006, the court held in that case that the development of offshore wind energy justifies higher support than offshore of wind energy based on land because of the extra cost for this type of production. Another case, 2010, after the court had referred the case for the preliminary ruling to the European Court of Justice, it held that the obligation to blend a growing percentage of biofuels into fuels for cars entailed no violation of the freedom of religion. Various European Union directives, the freedom of enterprise, nor of the free movement of goods. Furthermore, case 2014, in that case, the court recognized that there is a need to reduce greenhouse gas emissions and support for the development of renewable energy fits in that purpose. And the court said there is a wide margin of appreciation of the legislators, and techniques and the related economics are rapidly changing. And there is also some room for trial and error of the legislator, but the principle of legal certainty should be respected as regards investment decisions taken under previous schemes. And for example, fixed administrative fines per missing green certificates, it was the support mechanism, were found to be not to be unconstitutional. And the courts held they are not only a sanction, but also an economic incentive. And this has an impact on the proportionality test the court has to do. Furthermore, another case, 2014, the court held that the reduction or the limitation of car parking places in the Brussels capital region in the framework of environmental permits is justified in the context of its climate change policies. And the Constitutional Court considered climate change policy as an overriding public interest that justifies restrictions of various rights and liberties. And differences in treatment can relatively easily be justified, especially in the earlier stages of policy development. Emerging climate change law can thus be construed in a manner that is compatible with fundamental principles of the rule of law. Maybe a last case, it was about a complaint that the use of non-reusable and non-recyclable timber for combined heat and power generation had not the same support from the government than other types of heat generation. And the court held that not applying that advantageous support mechanism was not a discrimination vis-à-vis other forms of production of renewable energy, because the technique in the case still causes air pollution, and there is a risk that it induces increased wood clearance and therefore reducing carbon sinks. Climate litigation, and in particular strategic climate litigation, in which citizens and NGOs are requesting more ambitious climate action, is on the rise worldwide. You have already mentioned this. And often in those cases, an argument of separation of powers is invoked to decline the action. Indeed, the separation of powers is a strong pillar of the rule of law, but its precise understanding varies between various legal systems and jurisdictions. The argument was all the time present in the well-known Urgenda case. And the state of the Netherlands argued in first instance, in appeal and cassation, that it was up to the legislator and the executive to determine how ambitious its climate policy should be, and by accepting the claim and imposing more mitigation efforts on the state of the Netherlands, the judiciary would in fact take the place of the legislator and the executive, and thus violate the fundamental principle of the separation of powers and undermine representative democracy. It was finally up to the Supreme Court of the Netherlands to say a last word on this issue. And based on very detailed conclusions of two advocates generals of the court, and they are also available in English, the court dismissed the cassation appeal in a judgment of December 2019. And the Supreme Court based its judgment on the United Nations Framework Convention on Climate Change and on the state's legal obligation to protect the life and well-being of civilians in the Netherlands, as enshrined in the European Convention of Human Rights. According to the court, there is a broad, or was a broad consensus between science and the international community on the urgent need for developed countries to reduce greenhouse gas emissions by at least 25% towards the end of 2020. And the Supreme Court observed that the state had not explained why a smaller reduction can be considered justified and may still achieve the ultimate objective accepted by the state of the Netherlands. The state had defended the thesis that decision-making on the reduction of greenhouse gases belongs to policymakers. However, the court observed that the constitution of the Netherlands obliged the judges to apply the provisions of the European Convention of Human Rights. And the judge's task of providing legal protection is an essential element of the democratic rule of law. This is what the Court of Appeal did, said the Supreme Court in this case, and by imposing a global reduction target without prescribing concrete measures to reach that objective, it was argued that there is no breach of the principle of separation of powers. The legislator and the executive remain competent to work out the concrete policy mix of instruments to reach that goal, and are enjoying a large margin of appreciation in doing so. That decision of the Supreme Court of the Netherlands contrasts with the decision of the Brussels Court of First Instance in the Belgian climate case. So although the court came to the conclusion that Belgian climate policy was insufficient and in breach of the duty of care of the European Convention of Human Rights, it refrained from imposing a reduction order because it believed that that would be in conflict with the separation of power. And the judgment is under appeal on this point. Germany, I think, illustrates that the constitution can also be of great importance from another point of view. In February 2020, a group of young German people filed a legal challenge before the Federal Constitutional Court to Germany's Federal Climate Protection Act, arguing that the target of reducing greenhouse gas emissions with 55% by 2030 from 1990 levels was insufficient. And the complaints alleged that the act therefore violated their human rights as protected by the basic law, the Constitution of Germany. And the Federal Constitutional Court in the so-called Neubauer case struck down parts of the Climate Act as incompatible with fundamental rights for failing to set sufficient provisions for emission cuts beyond 2030. The court found that Article 20A of the Federal Constitution obliges the legislature to protect the climate and aim at achieving climate neutrality. And the court stated that Article 20A is intended to bind the political process in favor of ecological concerns. Also, and that's important, with a view to the future generations that are particularly affected. And accepting arguments that the legislator must follow a carbon budget approach to limit global warming to well below 2 degrees Celsius, and if possible, not more than 1.5 degrees Celsius, the court found that the legislature had not proportionally distributed the budget, the carbon budget, between the current and the future generations. And the court wrote, one generation must not be allowed to consume large parts of the carbon dioxide budgets under a comparatively mild reduction burden if this would at the same time leave future generations with a more radical reduction burden and expose their lives to serious losses of freedom. So the court ordered the legislator to set clear provisions for reduction targets from 2031 onwards by the end of 2020. Now, following that ruling and with a view to the new European climate target for 2030, as laid down meanwhile in the European Climate Act, the German federal government presented an amended Climate Change Act, and it was already adopted last year, so very soon after the judgment of the Constitutional Court. So I think following the reasoning of the German Constitutional Court that we may not postpone our mitigation efforts, otherwise the impact on liberties, fundamental freedoms will be dramatically for future generations. And in light of the most recent UNEP gap reports showing that we are not on track to reach the Paris objectives, the objectives of the Paris Agreement, I think it might be expected that the constitutional dimension of climate change policy will only be more and more and more on the forefront in the decades to come. Thank you.
Thank you, Luc. It was a wonderful combination of analysis of case law and also this ending for a prediction of the future. I noticed that the case law of your own court you referred to, it was of course very much about the weighing of different constitutional rights and interests against each other. And I got the impression that the interests of the environment and the climate seem to weigh quite heavily in your assessments. And also the comments on Urgenda and Neubauer, I'm sure that if we have some time to discuss after all the presentations, they will again come up to our grasp view. And our next speaker is from Australia, and I think we can forgive him not being here online because it's about 3 o'clock in the very early morning in Sydney. So I'm talking about Chief Judge Brian Preston, who is serving at the Land and Environmental Court in New South Wales. prior to being appointed in November 2005, he was a senior counsel practicing primarily in New South Wales in environmental planning, administrative and property law. I must say that Brian has breathtaking academic merits, and he has been a very respected figure in the international arena of environmental law already for several years. And now we will listen to a pre-recorded video by Brian Preston on climate litigation, government accountability.
It's a great pleasure to be able to present to the World Jurist Association's Energy, Transition and Climate Forum. This particular panel is concerned with the rule of law, energy transition and climate. I'm going to speak about climate litigation, and in particular about how climate litigation can hold governments accountable. Tackling the existential crisis of climate change requires ambitious action by governments to reduce greenhouse gas emissions from human activity. The goal is to achieve net zero emissions, that is, a balance between anthropogenic emissions by sources and removals by sinks. Emissions reductions need to be deep and rapid if we are to limit global warming to the agreed temperature target of well below 2 degrees above pre-industrial levels by the time target of the second half of this century, 2050. The government of a polity needs to take the lead in setting and implementing the strategic, policy and legal frameworks that are needed for effective climate action. The executive needs to execute these laws and implement policies for climate action. The judicial arm of government needs to hold the executive arm of government accountable for discharging these responsibilities. I want to examine a number of different ways in which the executive government may fall short of its obligations and how the judiciary can hold the executive accountable for these breaches of the law. The first way is where the executive fails to adopt a policy to mitigate or adapt to climate change that they are required to do under law. The example I'll give is a case that I decided called Bushfire Survivors for Climate Action against the Environment Protection Authority. I held that the particular statutory provision which imposed a statutory duty had been breached. The statutory duty was to develop environmental quality objectives, guidelines, and policies to ensure environment protection. The question was, did that duty extend to protecting the environment from climate change? I held that it did, and that the EPA had failed to discharge its statutory duty. I therefore ordered it to do so. The EPA has agreed to do so and has recently released a climate change policy and action plan. The executive government may adopt a statutory rule or a policy that's not authorised by statute. The first example I'll give is the recent case in the United States of West Virginia and the Environmental Protection Agency. The relevant EPA had adopted a policy which it was argued was not authorized by the particular statute. The US Supreme Court held that the Clean Air Act did not, in fact, authorize the EPA to regulate carbon dioxide emissions from existing coal-fired and natural gas-fired plants using a generation shifting approach that it had adopted in the Clean Power Plan rule. The executive may adopt a policy that is contrary to legislation. The example I'll give is the Friends of Irish Environment against Ireland. There, the Irish Supreme Court held that the Irish government's national mitigation plan, which sought to transition Ireland to a low-carbon economy by 2050, fell short of the specificity that was required by the relevant legislation, the Climate Action and Low Carbon Development Act. Accordingly, the Irish Supreme Court struck down that policy. The government may adopt a policy, but it may not implement them, and that is the breach of law. Laghari and the Federation of Pakistan is an example of this breach of law. The Lahore High Court held that the Pakistan government's inaction in implementing the policies it had adopted for adaptation to climate change breached the petitioners' fundamental rights. And the court ordered the establishment of an ad hoc climate change commission to effectively implement the government's climate policies. The executive government may also adopt a climate policy, but take insufficient action to advance its implementation. Another Indian case, the National Gaurav Kumar Bansai and the Union of India, was a case where the federal government had adopted a national action plan on climate change, but the various state governments had not implemented it. The National Green Tribunal directed the state governments to submit their own climate action plans, which would be consistent with the national plan, and to obtain approval from the national government agency. Alternatively, the executive might adopt a climate policy or take climate action, but that in itself breaches some other law. The agenda litigation in the Netherlands is an example of that. There were two alleged breaches of the law. One was that the Dutch government's unambitious climate policy and mitigation action breached its duty of care under the Dutch Civil Code, but as well breached the obligations under the European Convention on Human Rights. The Supreme Court of the Netherlands upheld the Hague Court of Appeal's decision that the Dutch government's inaction and unambitious action had breached various rights under the European Convention of Human Rights. The executive government may also just generally fail to take the adequate climate action. So a French case, the Notre Affaire Atout against France in the Administrative Court of Paris, held that France was responsible for failing to meet its climate and carbon budget goals under EU and national law. The court recognized that France's inaction had caused ecological damage from climate change. The court ordered France to take immediate and concrete actions to comply with its commitments on cutting carbon emissions and repair the damage caused by its inaction. In a recent decision of the UN Human Rights Committee, only on 22 September this year, the committee found that Australia had breached the petitioners, who were Torres Strait Islanders, rights under Articles 6, 17 and 27 due to the government's failure to address climate change. The Torres Strait Islanders had argued that these violations stem from the Australian government's failure to implement adequate policies and targets to reduce greenhouse gas emissions from Australia and to provide sufficient funding for coastal defence and resilience measures on the Torres Strait Islands. There also may be a duty to take climate action which the executive government breaches. An example is the litigation in Australia by children, led by Sharma, against the Federal Minister for the Environment. At first instance, the Federal Court of Australia held that the Minister for Environment owed a duty of care to the Australian children to exercise her powers under the relevant federal environment law to take reasonable care so as to avoid causing harm to the children that would arise from the emissions of carbon dioxide. Unfortunately, the primary judge's decision was overturned by the full court of the Federal Court. Nevertheless, there is pending litigation by two other Torres Strait Islanders, again against the Australian government, arguing that the government owes a duty of care to them to take reasonable steps to protect them, their culture, the traditional way of life, and the environment from climate change. They argue that the Australian government has breached its duty Australia's emissions reduction targets are not consistent with the best available science. They say that the duty arises from Australia's obligations under the Torres Strait Treaty, as well as commitments under the UN Framework Convention on Climate Change and the Paris Agreement. This case is listed for hearing next year. So by performing its essential role in holding governments to account, the judiciary upholds the law and the rule of law. Where those laws promote taking action to reduce greenhouse gas emissions by sources and increase removal of greenhouse gases by sinks, the judiciary's actions facilitate the achievement of effective climate action. Thank you.
Thank you. I'm sure we all pass our very best thanks to Justice Preston for a very versatile and interesting case law analysis and introduction. Again, the case Urgenda, which is now the paradigm case in strategic litigation, was mentioned. So it's time to move to our next speaker, who is Professor Dr. Ania Rytel-Warzocha. She serves at the University of Gdansk, Poland, in Faculty of Law and Administration, especially Department of Constitutional Law and Political Institutions. And she is a very renowned specialized constitutional lawyer. And she will tell us now about constitutional rights and counteracting climate change. Ania, please, you have the floor.
Okay, thank you very much. Let me share the presentation just to make it easier to follow. Okay, thank you. So before I start my presentation, I would like to thank World Jurist Association for inviting me to join the permanent forum in energy transition and climate. It's not only a pleasure for me, but it's also a great honor. And let me also thank to our moderator today, Judge Kari Kuusiniemi, for your commitment to the preparation of our today's meeting. So I will just briefly give you an overview of the relations between the climate change and constitutional rights and the protection of human rights in the context of environment and climate change. And then I would like to give you some perspective from the Republic of Poland, just to show the constitutional rights related to environment that we have prescribed in the Constitution, and then the possibilities of seeking legal remedies in case of their violation. And then I will just make some reference to the famous German case also, and finish with some conclusions. So it's widely recognized that climate change, which has become one of the main problems and global challenges recently, has a close impact on human rights, including the most important rights that are provided by the constitutions. So these rights have been recognized by the UN Human Rights Council, but also when we follow the cases, we can also find the rights that are taken by the claimants. So this is for sure the right to clean and safe environment, life to health, food, water and sanitation, self-determination, housing, education, and many, many more, which are both direct and indirect. The problem with the human rights and the violations resulting from the climate change is even more complicated for at least two reasons. First, we should keep in mind that in the global context, the most affected by climate change are usually those who contribute least to greenhouse gas emissions. Secondly, the impact of climate change on human rights has temporal dimension, so it will affect, or even more to a greater extent than the current generations, the future generations. And in this aspect, this decision of the German Federal Constitutional Court on the Climate Act is particularly important. It's an example of the implementation of intergenerational justice in the context of environmental protection. So when it comes to the protection of human rights related to climate change, it's not only important to recognize these rights in the Constitution, but also to ensure effective legal guarantees in case of their violation. It's also important to determine the duties of state authorities to combat climate change, and again, provide citizens with legal means allowing to enforce these obligations. So in this context, we can consider how courts, constitutional courts, but also common courts, could contribute to the prevention of climate change and thus the protection of these key constitutional rights. The growing awareness of people of the impact of climate change on their human rights is reflected by a growing number of climate-related lawsuits, including HYPE that has been already also mentioned in the following presentation. And the examples of the climate change lawsuit can be also found by at the website of the Center of Climate Change. So if you are interested in them, you can just go and search. There's quite a lot of different types that we can find already. So when it comes to the Republic of Poland, I will try to illustrate the above problems with the reference to regulations and constitutional practice of the Republic of Poland. So there are two questions, main problems to be answered. First, what subjective rights related to clean environment are provided by the current Constitution of the Republic of Poland? Does Constitution refer to in any way to the rights of future generations? What obligations concerning climate change are imposed on the state? But also, even more important maybe, it's the possibilities on the ground of the Constitution to construct legal protection of the rights to clean environment, both from the point of the current generation, but maybe also the future ones. So just to give you a short overview, when it comes to the Constitution, it refers to environment in several regulations. So the very general reference is already in the preamble, which states that we, the Polish nation, all citizens of the Republic, obliged to bequeath to future generations all that is valuable from our over 1,000 years heritage, established the Constitution. So there's no doubt that within the scope of these values is the natural environment as an exceptionally relevant example of assets that will objectively be of fundamental importance and probably even greater than today for future generations. Some other provisions more directly refer to state obligations. They require not only to respect human rights, but also to take active actions aimed to protect climate in order to ensure the right of present and future generations to enjoy a clean and healthy environment. So we have a very general Article 5, which define generally the objectives of the Polish state, mentioning also the protection of natural environment. But then that Article 5 also influence and determines even the text of these two articles that we can see, Article 68, which provides that public authorities shall combat epidemic illnesses and prevent the negative health consequences of degradation of the environment. Because of the obvious impact of the environment on human health, this provision imposes obligations on state authorities to protect the environment. So this time to protect another constitutional value, that is health. Article 74 provides other regulations that are important in that case, like public authorities shall pursue policies ensuring the ecological security of current and future generations, protection of the environment shall be the duty of public authorities. Everyone shall have the right to be informed of the quality of the environment and its protection, and also public authorities shall support the activities of citizens to protect and improve the quality of the environment. However, it should be pointed that from the protection of human rights and the ability to use that rights as the basis of lawsuits, it's quite weak, because both these articles contains the programmatic norms, so they cannot serve as an independent basis for the formulation of subjective rights. Additionally, the right to ecological safety provided in the 74 has been limited by another constitutional provision, which clearly provides that the rights enumerated in certain constitutional provisions, including this one, may be claimed only within the limits specified by the statute. So the main purpose of such regulation was to limit the possibility of invoking that article as a direct legal basis for claims, and thus limit the effective demanding by citizens to enforce of states' obligations in regard to certain constitutional rights. Attention should be also paid to another article, 86, referring, however, not to public authorities, but each individual. It provides that everyone shall care for the quality of the environment and shall be held responsible for causing its degradation. And also environmental protection is mentioned by the Constitution as one of the material reasons justifying the limitation by the legislator of the exercise of constitutional freedoms and rights. So now I would like to say a few words about the possibilities of asserting these rights before a constitutional tribunal and common court. So we can consider several possibilities. So the first one is the question: can we initiate the civil proceedings to protect our environmental rights? And the above mentioned Article 86 pose the obligation to care about the environment on both physical and legal persons, which is particularly important in the context of those enterprises which, due to economic activity, they carry out, particularly expose the environment to deterioration. So in that context, they can be sued, and the detailed provision is included in the Law on Environmental Protection Act. And also in the Civil Code, there is a provision that states that if a damage was caused by a failure to issue a normative act, so also an act concerning combating the climate change, whose issuance obligation provides for a legal provision, such failure to issue this act is confirmed by the court hearing the case for damage. However, in this environmental cases, it's very difficult to prove that the damage has already happened. So when it comes to these provisions, in practice, their application is quite limited. because and the first one is so far used only in the individual lawsuits against noise and we do not have any case law in which it would be applied to protect future generations or current generations against future potential harms caused by climate change. The other question mentioned here is whether can we, maybe there's a question, can the lack of taking actions by the government be sued? So in Poland, despite of the possibility I mentioned, that is quite ineffective because it's difficult to prove that the harm really happens. There is no possibility like it is in Germany. So in the allegations in German in German case concerning the Climate Act, it was not even a specific legal regulation, but the lack of an appropriate regulation relating to the rules of reducing CO2 emissions in years 2030, 2050, the object of allegation. In Poland, it would be impossible because the legislative omissions cannot be challenged before a constitutional court. We have several cases, opinions of the Constitutional Tribunal in which it takes the position that its role is clearly as a negative legislator, so it's only to review legal norms that have already been enacted in order to indicate they or determine the possible unconstitutionality and to eliminate them from the legal order. So the other problem is the constitutional complaint, because the ruling of the German Federal Constitutional Court on Climate Act was issued as a result of filing constitutional complaints by individual citizens and environmental associations. In the latter case, however, the complaints were found inadmissible, but when it comes to citizens, it was accepted. So when we compare the shape of the institution provided by the Polish Constitution, we can conclude that it would be not possible for several reasons. In Poland, in order to submit a constitutional complaint, it must be closely related to a case pending before a Polish court or administrative body. It can only concern the generally binding law statute applied to issue a final judgment or administrative decision. So it's a law in a positive sense, not only adopted by the parliament, but already enforced and applied by the court. And so this construction of the constitutional complaint excludes the possibility of formulating in the constitutional complaint an allegation of violation of the Constitution as a result of the legislator's failure to adopt appropriate regulation. And also, as I mentioned, article, even if we had another shape of the constitutional complaint, Article 74 as a program norm cannot be explicitly be treated as a subjective right and cannot be subject to constitutional complaint anyway. In this context, also the rights of future generations could not be protected by constitutional complaint, as the breach of constitutional right must be factual and already existing, so it cannot be merely potential in the future. So another possibility that we can, another solution where we can look for the protection is the abstract constitutional review, or the constitutional review that can be initiated by the courts by submitting legal questions. So in these cases, the above limitations concerning the constitutional complaint do not apply. So potentially, it could be, such an application could be addressed to the Constitutional Tribunal by one of the entities enumerated in the Constitution. Therefore, it may potentially happen that if the legislator passes an act that is inconsistent with constitutional obligations of the state, provided in Article 74, for example, they will be able to submit an application for the constitutional review of this act and its compliance with the Constitution. So in such situation, the program norm, that is the source of the futures and current generations' right to the environment, will become a point of reference, and the entity initiating such proceedings will de facto become a spokesman of the future and current generations. So the same can be applied to courts. So just to conclude, in the light of the Constitution, the regulation concerning the natural environment that we already have, both in the context of its protection and rights to a clean, healthy and safe environment, are relatively extensive, but there are no effective mechanisms enabling neither the enforcement of state obligations in this area or nor the effective protection of human rights in this respect. There are no legal mechanism and institutions for advance protecting the environment for future generations, such specialized ombudsman or guardians. We had such a discussion a few years ago, but now it's not a topical issue anymore. And the environmental case law that we have concerns more current problems related to other environmental problems, such as smoke, harmfulness of industrial farms, noise, pollution. So there's still a need for legal instruments to ensure that climate changes is effectively combated. Thank you very much.
Thank you, Ania. Thanks for introducing us to the constitutional law point of view to defending the climate, not only from the point of view of Polish law, but more generally. And personally, I just want to take up just one remark. I think it's of utmost importance that we recognize the different procedural structures which might be hindering the possibility of defending the environment from greenhouse gas emissions. For instance, how can we tackle the inaction of administrative authorities, the executive? Thank you once again. And our next speaker is Professor Christina Voigt from Norway. And already at the outset, I referred to that there is an ongoing COP27 in Egypt now. And because Professor Voigt is right now on her way to Sharm el-Sheikh, she cannot speak here online. So we have her pre-recorded presentation on the Norwegian Arctic oil case and constitutional environmental rights.
Warm greetings to everyone here from Oslo in Norway. First of all, I'd like to thank the World Jurist Association for kindly inviting me to the WGA Energy Transition and Climate Forum. It's a privilege being invited. And my talk today will be about the judgment by the Norwegian Supreme Court that was handed out just in 2021, but a judgment by the Norwegian Supreme Court concerning climate change. First of all, what was this case about? The case concerned 10 licenses for petroleum exploration in the Southeast Barents Sea that were issued by the Norwegian Ministry of petroleum and energy in 2016. And I included here a map of where this area is. This area was opened for potential oil and gas exploration in 2013. And in 2016, those first licenses to start exploring this area were handed out. And you can see it's in the very far north of Norway, between the coast of Norway and Spitsbergen or Svalbard that you see here. Now, I can also say that these 10 licenses that were handed out in 2016 and which led to these exploration activities did not lead to any findings of oil and gas. And all of these 10 licenses were in the end not used for actual oil and gas exploration. So these claimants challenged the validity of those 10 production licenses that I explained just in the previous slide. And they claimed that the licenses have the potential to lead to oil and gas production, and the exploration leads to oil and gas production, and the production leads to increased greenhouse gas emissions, which enhance climate change, and in that lies a violation of Article 112 of the Norwegian Constitution. That article was added in the revision of the Norwegian Constitution only in 2014, so just a couple of years prior to this claim. Later, when the case went through the Norwegian judicial system, the claimants also included a violation of Articles 2 and 8 of the European Convention on Human Rights, that is respectively the right to life and the right to private life, which are also included in Articles 93 and 102 of the Norwegian Constitution. The claim was first brought to the Oslo District Court in January 2018. The District Court decided, and the District Court said that Article 112 of the Constitution sets out a right. That's important because that was later reversed by the Supreme Court. Although Norway conducts oil and gas exploration and extraction, most of the produced oil and gas is being exported outside Norwegian territory to other states, either within Europe or to the United States, also to China. And it is being combusted there, either burned or used for other production processes. So the greenhouse gas emissions from Norwegian produced oil and gas do to a very, very large extent not happen in Norway, but outside the Norwegian territory. The Court of Appeal upheld the ruling of the District Court. It found that Article 112 requires that any environmental damage from emissions of exported petroleum products and at the same time dealing with climate change domestically need to be considered together. That was a very interesting finding because the District Court, the Appeal Court opened much more for including the impact that comes from exported oil and gas products that lead to so-called exported emissions as something that inherently need to be considered alongside with domestic greenhouse gas emissions. The Norwegian Supreme Court found that Article 112 of the Norwegian Constitution was not violated, that particular provision did not lead to the licenses being invalid. 11 out of 15 judges found the licenses valid. So the court said Article 112 of the Constitution protects citizens from environmental harm. And this is a duty of the government to adopt necessary and adequate environmental measures, but there is no corresponding right. The court found that the government had indeed acted because it addressed measures to reduce national greenhouse gas emissions, for example, through the emissions trading system, where Norway is a part of the European emissions trading system, or carbon taxes. And the third reflection here, very briefly, is that the court, in coming to its finding, did not take into account the Paris Agreement as, for example, an interpretative means to the duty of the government. The court recognized that the Paris Agreement exists. It also recognized that the Paris Agreement requires each party, and Norway, of course, has ratified the Paris Agreement, each party to put forward its best efforts or highest possible ambition, but it did not go into any analysis, legal analysis, whether the Norwegian parliament had actually adopted measures that correspond to that requirement in the Paris Agreement. The court also found that there is no violation of human rights because the link between the licenses granted and the potential increase in greenhouse gas emissions is too uncertain as to constitute a real and imminent threat to life and private life. Articles 2 and 8 of the European Convention on Human Rights. As I already mentioned, the dissenting opinions or the dissenting judges were of the opinion that there was a procedural error that the government or the ministry had taken by not taking into account the impact of the extraterritorial emissions caused by Norwegian oil and gas exports, and the environmental impact assessment that was indeed was carried out only looked at the national impacts, but not at what happened with Norwegian oil and gas once it leaves the country. So just to wrap up here in the end, so some reflection. It was indeed a very difficult case because it went straight to the core industry for Norway. The oil and gas industry, of course, is I do apologize for the noise here outside, is the core industry, which is the industry that established the Norwegian welfare state, and having a case that goes straight at that core industry is, of course, a very, very difficult case for the courts to decide. The second point, it's a new constitutional provision, that Article 112, that only came into the Constitution in 2014, and there hadn't been any case decided by the Constitutional Court on this provision. So the first time that provision came up was in this case with regard to climate change, very complex, very difficult. So if there had been maybe another environmental case first that kind of paved the way for the court of how to deal with 112, maybe it would have been easier for the court to render more, let's say, progressive judgment. Third point, here in Norway and in Norwegian legal culture, there is a rather restrictive take on judicial review. It is not necessarily a very litigation-friendly country in any case, but when it comes to judicial review of the acts of public authorities, we see a rather restrictive takes by courts at all instances. Fourth point here is that division between politics and law. The Advocate General in his statements would always point to the fact that this are issues of politics, it's not law. The Supreme Court shouldn't be dealing with that. On the positive side, there are some maybe interesting elements in the judgment that are worth taking note of. The first one is that the Supreme Court actually did open the door for the recognition of climate harm as a human rights violation. And the second door that was opened was that threshold that the court set up for a violation of Article 12, where it said if the parliament has acted or the government has acted, then it can only judicially review it in case of gross neglect. Now, the question is under which circumstances could it be said that the parliament has grossly neglected its duty to adopt adequate and effective environmental measures? And that may change over time. It is subject to interpretation. It's not set in stone, and the court didn't give us any indication, but there could be relevant criteria in the interpretation of when do we have a gross neglect. For example, the development of science, inclusion of the Paris Agreement or other international agreement, the interest of future generations. If all that is being taken into account in determining the threshold of gross neglect, maybe it may be lower over time. It may be easier to state that a gross neglect has happened by, for example, not accounting for extraterritorial emissions, Scope 3 emissions, due to exported oil and gas products. And now finally to the aftermath, and that's my final slide. That was not the end of the case when the Supreme Court rendered a judgment, because the initial claimants, now joined by Friends of the Earth, and 6 young individuals, which you see here on that picture, they filed an application before the European Court on Human Rights in Strasbourg against the Norwegian government. And at issue here is the question whether Norway has violated fundamental rights of Norwegian citizens, in particular Articles 2 and 8, as contained in the European Convention on Human Rights, through the adoption of the decision to license new blocks in the Barents Sea for development of deep sea oil and gas extraction, and through the failure to take the necessary measures to address the risk of the climate crisis. Norway, the government has asked to dismiss this case. It is scheduled now for deliberations at the European Court on Human Rights in 2023. It is currently put on hold. It is put on hold because there are a number of climate cases that are pending before the European Court on Human Rights, and the court decided to hear a number of the other cases first before it then will go and hear the Norwegian case. So we will all wait with expectation and great interest to hear from the European Court on Human Rights. I thank you for attention and wish you all the best for the rest of the conference.
Thank you, and our thanks and best wishes are now conveyed to Professor Voigt, to Sharm el-Sheikh, and we thank her for her very thorough presentation on the Norwegian Arctic oil case, and also by referring in the last slide to cases pending in the European Court of Human Rights. So as we know, there are at the moment there are 3 cases pending at the Grand Chamber of the court: the Portuguese, the Swiss, and the French case. But now it is my pleasure to thank all the distinguished speakers for tonight. It happened just like it always does, that when prominent experts are taking the floor, time flies, and unfortunately we cannot continue any further discussion or comments. I also wish to thank the World Jurist Association. You have chosen the most up-to-date and topical session by choosing the topic as climate change, energy transition, and the rule of law. And of course, it's my great pleasure to thank all those who have joined us tonight by listening the excellent presentations, and I hope that this is one minor step on our way to mitigating climate change by legal means, by courts and academicians with joint efforts. Thank you so much and have a nice evening, all of you.